Welcome to Cordell and Cordell's Men's Divorce Podcast, bringing you information for guys before, during, and after divorce, and everything related to family law. This podcast is not to be taken as legal advice, and no attorney-client relationship is established.
Good morning. My name is Michelle Ferreri. I'm a management partner in the Mount Laurel, New Jersey office. I am here today with Kevin Mammola. We are here to talk to you about preparing for the custody portion of your divorce. I am licensed in New Jersey and Pennsylvania, and I have been with the firm for just about 13 years at this point, and I've been practicing for almost 20 years. Kevin, why don't you introduce yourself today?
Thank you, Michelle. Yes, Kevin Mammola out of our Alpharetta office here in Georgia. I'm a lead litigator with our firm, as well as a member of the appellate practice team. And I've been with the firm for about 13 years as well. And I've been practicing law for about, 17, going on 18 years as well.
Okay, so why don't you get us started on what should a parent know going into a custody battle?
Sure. So whether you're going through a divorce or just have a straight custody case, obviously that's a pretty emotional type of case. There's a lot involved. Most of the time, both parties are heavily invested. There's quite a bit, one can cover in that topic, but we're kind of going to hit on some of the high points, just in general, some of the things you might expect as part of your custody case, some of the things you probably should look out for, and some of the things that can help you to prepare for your case. One of the first things I think is important to do is simply just understand your jurisdiction's laws. So in Georgia, obviously you'd be trying to understand a little bit of the custody laws in your jurisdiction. Now, I'm not saying you need to go out and study the law and know every bit of it with a fine-tooth comb, but I think it's important for the parties to have some grasp as to what the standards are for the court and what they look into.
Right.
So I think that's a good idea to get that knowledge first. You can discuss that with your attorney. But I think that in most states, the standard in a child custody case is probably the best interest of the child standard. It's a very big, broad standard. So I'm just going to kind of hit on some of the high points that, at least in our jurisdiction, I think probably most jurisdictions, judges do tend to spend a little bit more time on.
Sure.
I've got 4 factors that I tend to, discuss and identify early on in a case. One of the first ones under the best interest of the children standard would be the historical caretaking responsibilities of the parents, meaning, who would one typically be identified as maybe the primary caretaker of the children, who is the one that's feeding them, bathing them, taking them to school, picking them up from school, stuff like that. Now, there may be situations, obviously, where both parents are chiming in or helping equally. But that is one of the biggest factors the court will look at first. And I think parties need to understand that and be aware of that going into their case. The second factor that I think that's really important and that a lot of judges place really utmost importance on is co-parenting, essentially the willingness and ability of each parent to foster a relationship with the children and the other parent, meaning, are you going out of your way to show, to demonstrate to the children that your either ex-spouse or ex-partner is not the enemy per se, even though you may feel that way? The judges do tend to look at more favorably a parent that is not, disparaging or degrading the other parent towards the children and is really doing their best to foster that relationship with the children and the other parent. I think that is a factor that's heavily favored by most courts, and certainly in our jurisdiction here.
Right.
Other 2 factors I have is parental involvement and really the party's employment schedule. So parental involvement is similar to the historical caretaking responsibilities, but really what we're looking at there is how involved is the parent in their children's education, social life, extracurricular activities. Are they transporting the kids to the activities? Are they staying there for practice? Are they a coach? Are they an assistant coach? Are they the team mom or the team dad? Are they talking to the teachers? Stuff like that. And then lastly, one factor that I think is actually really important and one of the first questions that should be asked or addressed in a consultation when you're discussing child custody is each parent's employment schedule. So That's a pretty big factor, meaning if you have to commute really far and you're not home till late in the evening, but the other parent has a more favorable schedule, that certainly is something that could potentially put you at a disadvantage. But it's something that your attorney should know early on, so you could do your best to be prepared to either defend what the other side is going to say regarding your schedule, or see if there's a way to perhaps change your schedule, something like that.
Right. It's really important for us to know what you can and cannot do when it comes to your schedule, because you could want to have the children in a week on, week off schedule, but you are a police officer and you are working a specific work schedule that doesn't allow for that. So it's really important for us to know that information up front, so that we can then try to craft something that works well for you and gets you the maximum time with your children, but also understanding that your work schedule is not a super flexible one.
Well, that's a great point. I was just going to basically say, yeah, for people that travel frequently for work as well, it could be a potential impediment, similar to that.
Yeah. And I just wanted to make a point on the co-parenting. I think it's really important for parties to be aware when they're communicating, especially when they're in the middle of a custody battle, that at any point in time, their conversation, communication could be read or heard by a judge, and they should be hyper aware of that and try to be as kind and considerate and not confrontational as they can be, because that communication, especially here in New Jersey, and I'm sure it's similar in other states, that the parties' ability to communicate with each other is really important when it comes down to a schedule. And if the court is going to give an expanded schedule, like a 50-50 situation, or more than an every other weekend, they need to see that the parents can be adults about it and can be able to communicate about the kids on a regular basis. So I think that's really important. And everybody should, my advice is always assume the judge is going to read or hear what you say. And, don't tell your spouse what they should and shouldn't be doing. Leave that up to the judge. Just communicate, ask questions, and don't give commentary.
Those are great points, and that's pretty much exactly what I tell my clients as well. Any email or text you write while a case is pending, just assume the judge could be reading it, or a court-appointed professional like a custody evaluator or a guardian ad litem. Just assume that, and that'll do you well while the case is proceeding. And we have the same issues here in our jurisdiction as it relates to, like if you're asking for equal parenting time or more than standard, they are going to look to see if those parents can communicate effectively. So that's an important factor for the parties to understand early on in the case.
Right. Now, Kevin, do you ask your clients to set up a schedule or a proposed parenting plan that they think works for them in the beginning of the case?
That's a great point. I think that's an important thing to do early on in a case, is work with your attorney to develop a proposed parenting plan early on, because I think if you can look to see what you want the end result to be, then it's a little bit easier to build the blocks to help present your best case to try to get the result that you're looking to achieve with the court. So I think that you want it to be as detailed as possible, but in general, you're certainly looking for what type of parenting time schedule are you looking for. You want to take into consideration holidays, summertime. In addition to that, you'll want to discuss with your attorney how you would address or want to address some of the major decision making regarding your children, like where they're going to go to school, which pediatrician they go to, stuff like that. So those are all factors that if you don't start thinking about that until right before the trial, as a party who maybe hasn't done this before, they could feel really overwhelmed if they haven't given it the consideration. So if they start thinking about it before the case is filed or early on when the case is filed, they're going to be in a much better position and feel a little bit more comfortable when they do go to court for the hearing. So I think that's
right. I think that's really important. And I think also, if you have a case where you do have a work schedule where you can't be home when the kids are home from school, if you can try to plan ahead and put a plan in place to where you have assistance in line, so that when you do go to trial or you're trying to resolve your case, your spouse can't say, well, you don't have childcare. You can respond and say, I've planned for that, and this is what I have set up. So I think that's also good to start thinking about it in the very beginning, because you can make plans and not be trying to figure it out at the last minute.
I think that's a great point along those lines. I do suggest, too, that parties begin to think about where they want to live post-divorce as well.
Right.
So you start thinking about, what type of home would I want to have with my children post-divorce? So if you start thinking about those things early on, you're going to be in a much better position than just trying to scramble and think about those things at the last minute before trial or when you're at trial.
Right. Now, what kind of evidence do you gather in a custody case?
So with respect to evidence, there's a whole lot we could go over. We could probably spend a whole podcast talking about evidence and what type of evidence to use. But I'm going to go over just the broad strokes of what types of evidence we would be using typically. So it kind of falls into two categories if we're looking at it from a general global perspective. We have documentary evidence, and then we have witnesses, which is just evidence by testimony is how I look at that. So with respect to documentary evidence, here are some examples that may be helpful in your custody case would be your children's school records, their medical records, documents that demonstrate your involvement in the children's lives and your ability to care for them. So just as an example, perhaps you can go to your child's pediatrician and maybe they have records to identify which parent took the child or children to their appointments. I mean, that's something that you can use to show that you were the one taking the children to their appointments, or you can use it to demonstrate that you and your spouse were both taking the kids and you were just as involved as your spouse is or was with the kids.
Okay.
Photographs is documentary evidence. I think that could be helpful. I do sometimes recommend to a client you can look at, if they're heavy on social media, we do try to advise to avoid that a little bit during a divorce, but I have found that it's a helpful tool for some of them to go back in a timeline, because a lot of parents will post pictures of them with their children doing activities over many years, and they'll have a date stamp typically on that. And that's just one, sort of simple way where they could go to one source and try to maybe get a timeline of photographs that present their involvement in their kids' lives.
That's a great idea. What kind of witnesses do you use in a custody case?
So you can use any kind of fact witness you'd like. I'll say here's some of the more common ones. Now, most people will often get a family member to testify as a witness in their custody case. And there's nothing wrong with that because, they're usually often more than willing and helpful to come to court and testify on your behalf. The only potential downside to that is that person could be perceived as biased to the court since they're related to you. However, if they do have specific observations that they've observed of you as a parent, I think it's still a good idea to take the parent regardless of, have them testify regardless of the fact that they're potentially perceived as biased to the court. Another potential helpful witness can be teachers and school staff. They can, potentially testify to the child's academic performance, their behavior at school when they're, with one parent versus the other. So that they can be a very useful tool, and a lot of parties do want to use teachers and school staff. The only thing I usually advise my clients is that they will typically try to avoid being called as a witness as much as possible. And that can be a difficult way to get them to willingly testify to help you. But one way to get their information and testimony considered by the court, from my experience, is to use a guardian ad litem, and that person can talk to the teachers, the school personnel, the school staff, and they can include those discussions as part of their recommendation. At least here in Georgia, I know that has some potential hearsay issues, but in Georgia, that type of information can be considered by a guardian as part of their investigation and recommendation to the court.
Right. And I just want to point out that, again, that I'm licensed in New Jersey and Pennsylvania, and Kevin is licensed in Georgia. And it's really important if you're going through a custody battle to talk to an attorney in your state so that you can understand exactly what the law is and the evidence rules and what can and cannot be used in your case. These are just our suggestions in our states. And so we encourage you to take some time and talk to an attorney in your state to learn about how custody works there.
A few other, we'll just kind of run through these quickly, not spend too much time on other witnesses you might consider. Would be child care providers. I mean, certainly they could be helpful, like babysitters, nannies. Friends and neighbors. I think that, a friend always has the potential bias that a family member, a perceived bias that a family member may have as well. But again, if they've observed you with your child or children, they can still be a great witness, and you don't want to exclude them just because they happen to be a friend. Neighbor may be a good witness as well. They're probably considered a little less biased. Other ones would be law enforcement officers, court-appointed professionals like a guardian ad litem or a custody evaluator if one is appointed. And then in some cases, although a little bit more rarely, the child or the children can testify. However, here in Georgia, and probably in most states, we typically don't have the children testify on the witness stand. They typically would go back in chambers with the judge and talk to the judge privately in our case.
Right, that's the same here. And sometimes they will also talk to the guardian ad litem or the custody evaluator if they're involved in the case.
Okay.
So wrapping this up, can you just give a brief overview of how you prepare for the actual custody trial when you're getting down to the wire and the trial's coming up?
Sure. So here's kind of a brief overview of how one may want to prepare for the trial. Just some kind of highlights. So that I recommend for a party going through a custody battle, whether it's a divorce or just a custody modification or custody establishment of your rights. When the hearing is scheduled, at some point in time, try to familiarize yourself with the courtroom. I think that does help a little bit with the anxiety that someone may feel if they've never been to court before or they've never testified before. If you can't get yourself to the courtroom, and even better, if you could watch a hearing in the courtroom with that judge, that's actually better. If you can't do that, talk to your attorney, and that the attorney can kind of give you a lay of the land as to where we're going to sit, where the witness box is when you're testifying, where to look when testifying, stuff like that, just to kind of help ease some of that anxiety of the unknown.
Right.
You want to know the procedures of the court that you're testifying in, and by that I mean you want to go over with your attorney sort of what to expect procedurally, meaning which side is going to speak first, which side is going to present their evidence first, who gets to speak last, stuff like that. And just as another example, when someone at a hearing, one of the attorneys says objection, the party testifying needs to stop, wait for the judge to rule on the objection. And they don't always know that. Oftentimes they'll just keep speaking, and that could kind of bug the judge. So you want to make sure that your attorney does advise you on all the things that what to expect, and also what may or may not bug the judge, so you don't bug the person that's making the decision.
Right.
Just a few other things I'd say would be to you want to create a chronological timeline of significant events leading up to the divorce or the filing of the case. I think it's a good something good to go over with your attorney. You definitely should, before your hearing, practice answering questions. So it's a good idea to work with your attorney to practice answering questions that your own attorney may ask, which is known as direct examination. But you also want your attorney to throw some potential cross-examination questions at you, so you kind of know what to potentially expect. I mean, we can't predict exactly what the other attorney is going to ask on cross-examination, but typically we can give some pretty good examples as to what to expect. And it's really important that you go over that with your attorney. Just a few things to kind of wrap this up. I know this is probably hard to do when you're at court and testifying, but you do want to try to stay calm and collected. If you need to take a breath or take a break, by all means, you should ask for that. Dress appropriately, that should go hopefully without saying. But what I say most importantly, and I think the judges will tell you, is to tell the truth. Because even a small lie or fib, however you want to look at it, if discovered at a hearing, can oftentimes by the judge, it'll reflect so poorly that it poisons not necessarily all your other testimony, but a lot of it. And if there's any doubt to any of your other testimony, if you've lied on even something small and minuscule, it may reflect poorly on you. So it's really important that you do tell the truth. And if you have bad facts that you're worried about being exposed, you need to go over that with your attorney and develop a strategy to find the best way to go ahead and present that information to the judge in a way that may not make you look as bad as if the other side was presenting the evidence and trying to make you look bad.
Well, so thank you for those tips, Kevin. And I think that this was a really great overview of preparing for a custody case in any jurisdiction. So thank you for that.
Thank you, Michelle. I appreciate that.
Thank you so much for joining us for another episode of the Men's Divorce Podcast. If you'd like to set up a consultation or learn more about our law firm, you can go to CordellCordell.com.